Hi everyone, could I ask you to draw your attention to the front of the room, and we'd like to get started if we could, please. I'd like to say that we deliberately gave you a little bit more time to enjoy your lunch and to network with each other before we started. But I'll confess, actually, I was caught out by the fact that we were starting at 1:15 and not 1:30. So the moderator was late, and I apologise for that. So let's get cracking. My name's David Wiseman. I'm a professor at the Faculty of Law at the University of Ottawa. Today, this panel that you're at is the panel on re-engineering professional roles and regulations for a learning justice system. I was going to take it back to the more general PowerPoint, but that's okay. So, joining us on and just to say a little bit more about that, the session examines how professional regulation, licensing and ethics can evolve to sustain people-centred justice. We'll explore ways to build a justice workforce that is more diverse, flexible and responsive to public needs. I'm going to start with a brief presentation, and then we'll have two more substantial presentations. One from Ashley Stasiewich, who is an instructor in the Paralegal Studies program at MacEwan University and a doctoral student in the education program at Athabasca University. Then a following presentation with two presenters as part of it. To my left, Max Bilson KC, who since June 2023 has been the Deputy Attorney General for Saskatchewan. And to my right, Pamela Kovacs, who is Policy Counsel at the Law Society of Saskatchewan, in which role she works on a number of portfolios, including communications, equity, diversity and inclusion, truth and reconciliation, and the future of legal services. So not much to keep you busy there, Pamela. In today's session, so from the main presentations, we're going to be hearing about two examples of non-lawyer assistance for law-related problems. Ashley will discuss a research project she'll be undertaking in relation to paralegals in Alberta, who are not only non-lawyers but also non-regulated. Max and Pamela will discuss a new regulatory initiative in Saskatchewan allowing for limited licensing for non-lawyers. I'm just going to take a couple of minutes at the start to offer a little bit of broader context for those examples of non-lawyer assistance and to situate them in relation to other initiatives and options for non-lawyer assistance. In doing so, I'm going to briefly spotlight the option of supporting and enabling community justice help, which is the law-related help provided by staff at not-for-profit community organisations. I want to give that a little attention just because I think it's important in the context of thinking about people-centred justice. Wrong emphasis in that sentence. I'm going to give it some emphasis because I think it's important for thinking about people-centred justice, although that's most definitely not meant to mean that the other initiatives are not also relevant to people-centred justice. Indeed, the main point of my remarks is going to be that we need to recognise that these and other options for law-related assistance can or should offer a broader ecosystem for advancing people-centred justice. But also, as we have heard many times already at this conference, we need to remember that there are many people who never engage the legal system, and so our ecosystem needs to be developed to include them too. Not necessarily to join them to the legal system, but to enable them to achieve access to justice by whatever means works for them. For me, this broader vision is one of community justice empowerment, which I would say is similar to the idea of, inspired by the idea of people-centred justice. So, if I can move to the next presentation. Oh, whoops, wow. Okay, just briefly then, the starting point is recognising that there's a dominant paradigm and a general paradigm that we're working with from a regulatory point of view. Its key elements are that across Canada, it's lawyer-centric. There's a foundational prohibition, legal services from lawyers only, and legal services are defined very broadly, but there are specific extensions and exemptions that allow legal services from specified non-lawyers, across the country. And regulators of legal services can contribute to nudging and shifting away from this general paradigm of lawyer-centrism and advancing access to justice through how they deploy or don't deploy their regulatory responsibilities. As you would know, different jurisdictions across Canada have different arrangements within this general paradigm and are nudging or shifting in different ways to different extents. This can be represented on a chart that was put together in 2020 for research that I did with Julie Matthews, hi Julie, for Department of Justice Research and Statistics Division, trying to map some of this landscape of differences and similarities across Canada. This is provinces and territories. And so you'll see that, lawyer-centric orientation across the top with the foundational restriction, but then different types of extensions and exemptions differently arranged across the provinces and territories. The yellow ones are indicators of programs that at that time were in progress for expanding some of the extensions or exemptions. For instance, at that time in Saskatchewan, limited licensing was just being considered as something to do. Now it's happening and we're going to hear about that. There's others, similarly Manitoba at that time, and I think they're nearing a new system there as well. So that's just a brief sketch. I'll come back in a minute to the yellow highlighted bit, which is on non-legal professions or occupations and gratuitous provision, because that's potentially where community justice help can already fit into regulatory schemes. So that's provincial and territorial. It doesn't include federal jurisdiction, and it's not including Indigenous legal orders, both of which should, of course, be considered. I'm going to focus here just on adding a couple of things on the federal dimension. So federal jurisdiction, immigration consultants, this allowances under Section 91 of the IRPA for non-consideration-based assistance. And of course, the federal government plays a key role in the Indigenous Court Worker Program. So that's sort of just mapping a little bit the framework that we're in. Limited licensing then in Saskatchewan, as we'll hear about, offers a new part of this. We should recognise that a number of jurisdictions in Canada and around the world, in fact, have legal services sandboxes, which are typically allowing lawyers to do new things or non-lawyers to do things in delivering legal services and trying to advance access to justice. Paralegal professional development, we're going to hear about as well. And then community justice help, we've heard actually about a lot at this conference too, thinking about the role of non-profit or community sector workers in supporting and enabling access to justice. And there's work being done by various bodies around the country on sort of how to support and enable community justice help. We've heard about that in some of the programs. There have been frameworks put together on what good quality community justice help looks like. And this is building across the country, I think. If you're interested in thinking more about what we understand about community justice help and what its role might be in the ecosystem, then this deck ends off with a few resources. A recent example of more work here is at the bottom there by the CCR, the Canadian Council for Refugees, they've put together a guide on building quality justice services for newcomers, and this is aimed at refugee-serving agencies and community workers in those agencies to contribute to the broader ecosystem for newcomers. Okay, so that's it from me. I was just hoping to sketch the landscape a little bit more, against which we'll now hear about some specific examples. So I'll pass things over to Ashley.
just loading. Okay. All right. Hi, folks. I'm going to skip to this third slide here just for brevity. So can you hear me okay if I talk like this? So I'm a doctoral student, and I had originally planned some speaker's notes, but most of what I was planning to open with has been reiterated in almost every single session. So I'm just going to jump right into it and explain a little bit about why I'm doing this work and my positionality here. So as a doctoral student, we spend a lot of time thinking about our positionality. And to share with you, yes, I am a faculty member at MacEwan University. I teach in the Paralegal Studies program. So if you have hired someone in Alberta from MacEwan's paralegal program, I've probably taught them, so you're welcome, or I'm sorry. But what that role has allowed me to do is get a chance to, I actually place my students in their practicums. So I get to learn from a lot of folks in legal organizations and in law firms from a range of areas of law. But secondarily, I've also worked in the industry for almost 20 years with Moreau Law. I'm not a lawyer. I started as a file clerk, and I've been their office manager for the last decade, and I did some paralegal work and legal assistant work as well in between there. So I bring a really interesting lens to this doctoral research that hasn't really been discussed in paralegal education in Canada. What I'm finding in my early research for my literature review, I'm at the proposal stage here, is that there isn't a lot of literature on paralegal education in Canada. I'm drawing primarily from the States, but also from folks who are not lawyers in this space. So really my research here, I want to be very clear, is not advocating for or against regulation here. It takes a very neutral stance. But really what I'm exploring here in the Alberta context is the education of paralegals. So my positionality is important here in this context. Because what I've seen anecdotally and in the literature is that we have an uneven access to education for paralegals. And this is kind of problematic because we have a very large unregulated legal services market in Alberta. So I like to situate paralegals in Alberta in two kind of major camps. And of course, there are exceptions, but we have paralegals who are working under the supervision of a lawyer. And then we have paralegals who are working independently with literally no supervision at all. And they're kind of working within the gray areas of the law. So whichever way we look at this, folks, like regardless of whether regulation occurs or not, paralegals are still going to continue doing this work because they are meeting an unmet legal services gap, particularly in this independent kind of sphere. And those individuals practicing there are the ones that have the greatest concerns with respect to public interest, which if you've seen that latest CBC Go article is a concern. So again, I don't want to reiterate what we've seen in other sessions, but paralegals in this context are supporting kind of that middle ground, right? We saw this in the presentation earlier. Now, in exploring the education opportunities in Alberta, the formal education opportunities, what we see are a few different things. I'm going to kind of go back and forth with slides, which I'm really sorry in advance. If we look at just the formal education opportunities that are available in Alberta, there are only 3 paralegal-specific programs in the province. So one of them is MacEwan University, and that's a university program, that's a diploma. The other 2 are through vocational programs, and those are through private training colleges. And so it's a certificate or a diploma. So we're thinking like the Robertson College. I'm not saying like for or against vocational training opportunities. There are certainly some that are fantastic, but it's also potentially the opposite could be the case. But the third also area of learning where we see a large component of paralegals learning is workplace-based training, where a lawyer took interest in someone and said, I'm going to train you to be an excellent paralegal, which is exactly what happened to me. And so we have these kind of like different ways, these different pathways of education in Alberta. The other concern here, other component when we look at education in Alberta is its fragmentation and the delivery methods. So in MacEwan's case, it's an urban university. The program is 2 years long and it is all pretty much in person. Okay, so we create an inequity in access for this education. But the vocational training programs, they have online, hybrid, in-person, what do you want? Dealer's choice, okay? And so this creates a different kind of lens here of inequity because if you can go to this urban center and take 2 years off of your life to get this paralegal diploma, great. But it creates this inaccessibility for the folks who are, the ones who can only do the online training are the ones who end up in these vocational training programs. And if we look at career trajectory, or if someone wants to continuously upskill for, academic credentialing, typically those vocational colleges, I mean, I'm referring to like the Robertson College, this is not me saying that it's not a good program, but what I'm saying is it doesn't typically transfer to a university or college academic credit-wise. So if you take a 1 or 2 year diploma through these organizations and you say, hey, you know what, I think there's a gap in my knowledge, I want to learn more about, get a business degree or learn more about accounting or, go to get a legal studies undergrad. Well, you have to start from the beginning because typically those courses don't transfer. And so we see this like kind of ceiling that gets, put on paralegals. But there's also a gendered component to this, which I'm going to go back here. It's at the bottom part of my slide here, is that the paralegal workforce, we have the data, we can draw parallels in Ontario. What is it, like 68% of paralegals are women. And if we look at the statistics about how people are accessing education, typically women are caregivers, and those considerations affect how they can access formal education opportunities. So when we look at what's available in Alberta for formal education, we have the vocational having the online learning, and we have the university that is only in person. So we already have this kind of a disparity. Which begs the question, if we're wondering why there's no diversity in the workforce, well, we can look at the education here. And you're probably wondering, well, Ashley, why did you focus on professional development and not education? Well, at current, in an unregulated environment, there is no entry to practice requirement for paralegals. All of us could call ourselves paralegals if we're not lawyers, okay? Anyone could call us without any sort of education requirement. So really where the formal education is chosen, it's more of a volunteer thing to get your name on the list of applications to apply at a firm. But plenty of firms hire folks with no education at all, and they say, I can train you to do the job. And so it makes it really hard for me to focus my research on just the education that folks are encountering, which is why I'm conceptualizing professional development using the term of like accessing education to benefit your workplace. As a term that encompasses not just formal education, but also those informal education opportunities that you see, maybe you experience in the workplace through mentorship. Maybe it's something that you're accessing online. Maybe you're using generative AI to help you through some of the training gaps that you're seeing in the workforce. And really what I'm looking for here is to explore how paralegals in Alberta are experiencing their current professional development, how they're perceiving it, how they're accessing that information. Because whether they're operating independently or if they're working with a lawyer, we still need to have quality, competent paralegal support, right? A lawyer, it's such a huge risk for a lawyer to delegate tasks to their paralegal and be confident that the work's going to be done well, that they can trust them. But so many folks have told me anecdotally, hey, like I don't know what they know, or I'm concerned about this. This is a huge risk. The responsibility is all mine if they mess up, which is a fair and valid concern. And as an independent, we could probably spend some time on Google and find a variety of cases where folks are misled from, a bad actor. And so what I'm hoping to is, just kind of get essentially a needs assessment of sorts, for the lack of a better word, of what's currently going on in Alberta, what paralegals are accessing as far as education, what gaps they're noticing, why they're accessing certain professional development, online training, what have you, what would be helpful that they perceive to be helpful or what's not helpful, and in the hopes that this would inform regulators who are wondering what kind of education paralegals might have, post-secondary institutions to maybe fill some of those gaps, or even private training institutes. We're seeing a lot of private law firms too that are offering some courses to help with some of these gaps that we're noticing in current paralegal programs. But that's really the whole study that I did the shortest. I'm under time here, but that's really kind of what I'm looking for here and what I'm exploring. So outside of this session, if you have any sort of suggestions for me, I'm still at the proposal stage, or any sort of scholarship that you're aware of, please come chat with me, because I'd love to hear from you, because this is an area that is really kind of under-researched, and I want to have more voices here to bring this to light. So thank you. Yeah.
Thank you. My name is Max Bilson, as you've already heard, and thank you. It's lovely to be here to speak about a project, a new type of service in Saskatchewan that has taken many years to develop and was the fruit of a very collaborative process between government and the Law Society of Saskatchewan. And I want to underline how important that is, that this is, I think, a very good example of where government can work with law societies and with others to achieve something that I think will be very meaningful and impactful to the access to justice and the rule of law in Saskatchewan. And I'm going to be talking about, or we're going to be talking about, the limited licensee program, and I'll give a little introduction where I'll ground the program, and then Pam will take you through much more of the detail. Like many jurisdictions, if you cast your mind back to 2017, 2018, when this all began, the world was very different, and we had very different problems back then. We had increasing demand for legal services. We had increasing costs for legal services. We had underserved communities in the specific geographic sense, but also underserved communities, as you've heard many times in the last few days, underserved communities, whether Indigenous, whether language communities, whether other communities. And so in 2018, the Ministry of Justice and Attorney General and the Law Society formed a task team to help address these underserved markets and communities in Saskatchewan with a focus on rural and remote communities. The task team also addressed affordability and language cultural barriers to legal service delivery. It was created to respond to these pressures in a coordinated, system-wide way. And it reflected a recognition that no single institution could solve these issues alone. And the task team included members, therefore, from across the legal community and had support from a joint staff working group. And I'd like to name check some people at this point who were important in that task team and were important to me as mentors and as people who were very important in my professional life. Mary Ellen Welsh Casey, who passed away a couple of years ago, was in effect the lead on the task team. And Gerald Taggart Casey, who is happily still with us, was the Deputy Minister of Justice and Attorney General at the time. And they were formative, along with the Law Society in that task team. And to quote the task team's final report, the Legal Services Task Team was appointed to examine whether service providers other than lawyers should be permitted to provide some legal services in Saskatchewan. And this task team identified 3 reasons to support the rationale for this, for its existence. One was greater access to legal services, as you would imagine. A second was more consumer choice, to allow a wider to allow the public, clients in the public, to have more ability to pick and choose the type of service they wanted to access. And the third point was the boundary question as to how do you effectively regulate legal services where you have a gray area of people delivering legal services without any regulation, without any kind of boundaries to them. Or to that service. And so those were the 3 the reasons that the task team gave. And the task team concluded that it was time to move towards greater flexibility in the regulation and delivery of legal services. And it made the 13 recommendations that are on the slide in front of you. These recommendations are included in its final report, and they include amendments to the Legal Profession Act, changes to the rules of the Law Society, and other necessary changes. And the Law Society and the Ministry have had joint responsibility for the implementation of these recommendations. And at this point, I will pass it over to Pam to take us through the rest of the presentation. Thank you.
Thanks so much, Max. Nice to join you all here this afternoon. I am coming from Treaty 4 territory, and I'll just get you to note the objectives on the left-hand side there. We'll return to these. They were the basis of the framework we used to try to understand if, in fact, limited licensing was meeting those noted objectives. And so there is a final report from limited licensing available in the materials and on our website. It has been a journey of 10 years or more almost. I joined partway through that, so kudos to the folks before me as well as Max has mentioned. And essentially, we took a bit of a staged approach to implementation because this did involve changes to the legislation, changes to the rules, and a lot of engagement and consultation along the way with the profession, with the affected public, and with various stakeholders who would be impacted by this, but also part of these changes in the regulatory framework. So a staged journey, and you can learn more about those stages in the report. I would just point out that there is also a lot of articles where we talked about the ideas and thinking behind what we were trying to do and what we were ultimately trying to achieve, which speaks to Ashley's point about a competent and ethical paraprofessional workforce in the province who are serving the needs of the public. And a big part of the work was to try to understand those needs, and thanks to Create Justice and other partners in the Saskatchewan Access to Justice Network who supplied that research and foundational understanding through needs studies and other work, which helped us create a fit-for-purpose regulatory framework in Saskatchewan based on the needs identified, and also thanks to the Stats Canada Canadian Legal Problem Survey, which informed our work as well. And so what we ultimately ended up was with a flexibility in regulation that is still lawyer-centric. There certainly is a lawyer-centric nature to this, and the language of it in terms of how we talk about other participation in the legal profession. However, we now talk about regulation of the practice of law. We regulate, as the Law Society of Saskatchewan, the practice of law as opposed to just lawyers or just limited licensees. And this regulatory framework has a number of components. So, of course, we still regulate lawyers, and through lawyer supervision of paraprofessionals, we also have a robust paraprofessional market in Saskatchewan. Then we have another class or category of licensee, which is limited licensees, and I'll speak to that a little bit more in a moment. But like many jurisdictions, we also have the legislation which provides exemption from unauthorized practice of law and creates a number of folks who are engaged in the delivery of legal services and the practice of law. And then in our rules, so the Law Society of Saskatchewan rules, we also have categories of exemption where, again, cohorts of individuals are allowed to engage in the practice of law, the delivery of legal services, and do not fall under unauthorized practice. And this is a flexible list. We can grow this list and this understanding over time, meeting new needs and new responses as they might arise. And one of the changes in the Act was also the deregulation of legal information. And so we actively encourage legal information provision by partners, community organizations, and others. And a shout out to the librarians. We have active legal librarians, law librarians in our province who do a lot of work to help work with community organizations and really deliver legal information in effective ways where people are, meeting people where they are. And there's also a network of public law librarians, public librarians, and others, newcomer organizations, court workers who are involved in the delivery of legal information. And we actively encourage that. We come and do presentations and engage with those groups regularly. So that's the overall flexible framework. And then, of course, If you aren't in one of these pathways, we still do have the unauthorized practice of law and are concerned if we find folks outside of these pathways, there's effective regulatory pathways or exempted or accepted pathways. So if you're outside of one of these, then we would like to talk to you and figure out if there is a regulatory pathway that makes sense, or if not, I mean, maybe we need to consider that, or maybe you shouldn't be doing that work. And so when we look at the regulatory standards, we talk a lot about right touch regulation. We're not interested in over-regulating where we don't need to over-regulate. We are interested in regulating where there's a good reason. And Ashley mentioned a recent news article that highlights why regulation can be important. And so essentially, if you move from the left of the screen to the right of the screen, you'll see lesser and lesser oversight or regulatory reach by the Law Society of Saskatchewan. And you'll see the standards that apply from the entrance requirements through education, continuing professional development, which is important, and then all the way down to, is there that regulatory oversight body? We have frequently asked questions about these various categories available on our website, and this is explained more in the final report as well. Just a quick note about terminology before I dive into limited licensees. We had talked a little bit about identifying some of the areas that will require further reflection and discussion as we move forward, and this would be one of them. So we did not adopt the term paralegal in Saskatchewan simply because it was a term commonly used, similar to Alberta, where you would find folks with that title in law firms, in government, in a variety of places. And of course, we have in Ontario a dedicated understanding of what being a paralegal means, which does not entirely match to the Saskatchewan limited licensee definition. Essentially, there's more flexibility. The pathway of education, training, and experience is not standardized for limited licensees, where it is for paraprofessionals, and the scope of practice for limited licensees is not standardized, where it is for paralegals. So something to be reflected on as we move forward, and noting that our colleagues in the States have also done quite a bit of work around this and done a lot of focus groups also in other languages, and they land on the title of legal practitioner as a more common standard. Okay, so very quickly, I'll just walk you through what we learned from the pilot, which was for years. We had the opportunity to collect data as we went through the pilot and reflect back on, were we able to meet those objectives initially set out in the Legal Services Task Team report. As with any study, there's data limitations based on who chose to participate and the reporting of pilot participants, and limitations in terms of we didn't do practice audits with all of the pilot participants. But overall, we had a good sense of what was happening in the 4-year pilot, where we had 44 applicants and ultimately about 28 that were active throughout the majority of the course of the pilot. We did see transitions, none of them for nefarious reasons or reasons we were concerned and pulled a license. This was much more related to natural transitions, retirements. We tended to attract an older practitioner into the pilot. And ultimately, 9,000, just over 9,000 folks were served through the pilot in that 4-year period by those 28 or so pilot participants. You'll notice, just I like to highlight when there's a data point that kind of makes you raise your eyebrow. There are quite high numbers of client inquiries. This was related to a particular practice area, property tax assessment, where you have a very high volume of inquiries and much fewer people actually engage and have services. So that's the difference in those numbers there. And ultimately, we did have The majority of folks indicate positive consumer reviews. We asked folks in the pilot, what was your experience? We on purpose didn't make it just a complaint form. We made it a consumer review form because we wanted to attract both the positive and the negative that might come out of it. So ultimately, by far, a majority of folks were pleased. From the ones that were negative, we looked into them, we investigated. For the majority of those, it tended to be communication problems, which tracks to what we see with lawyer complaints as well. Okay, and so when we look at that summary of findings very quickly, essentially positive impacts, or I will let you know in a year for the last one. In terms of the demographic data, are we seeing more women or men? Are we seeing folks with different languages? I have anecdotal information about that, but we'll wait till the formal demographic data collection in a year. But essentially, from an affordability standpoint, limited licensees were charging less than lawyers. When you look at Western Canadian averages, the lawyers will tell you that's an imperfect measure. We would accept that. It's the best available measure we have. We also saw a positive impact in terms of the choice, more folks available to provide the services, and being able to find a practitioner as evidenced by 300 geographic locations that were being served by the pilot. And the pilot folks being outside of Saskatoon and Regina, which is where we have the majority of our lawyers. And ultimately, we achieved a bit more of that clarity in regulation in terms of unauthorized practice and what's possible. So overall positive impacts with a bit of an asterisk in that we'll learn more as we proceed. And so just very briefly, you will now find in our rules a framework for limited licensing, which includes a code of professional conduct. You must complete a mandatory course on ethics before you even apply for the license. It's part of the application process. And ultimately, there's the same regulatory framework you would see for lawyers. To an extent. There are some differences, particular related to the scope and other aspects, but they're insured, there's an indemnity fund, there's the same sort of application. And so from January 1st of this year, we began receiving applications, and it's similar to what you would see for a student at law or lawyer joining the profession. Also, the same fees would apply. From the education and work experience angle, there are requirements. You are required to show education, training, or experience linked to the scope of practice you are aiming to provide services in. We maintain a list of recognized schools, and part of the pilot was understanding the diversity of backgrounds that might come into the pilot and ultimately licensing. And there's a chart in the final report where you'll see a range of education, some of it justice and law adjacent, some of it directly law and justice, and then this broader framework of folks who are bringing additional education and training now into practice of law areas. It does have to have a nexus, your education, training, or experience to justice and law, and it's not a replacement, for instance, for the national accreditation process. Although we are finding that internationally trained lawyers are also interested in the program, possibly as a temporary licensing framework or possibly more long-term if they have a particular area of practice that they're interested in. And what are those areas of practices? So the list is on the screen in terms of what we saw in the pilot and have started our licensing basis on with the understanding that this can grow. So each applicant is considered on a case-by-case basis, and this list may evolve over time, and it's individualized to the individual providing the legal services or engaging in the practice of law. But essentially, these are the main areas of focus that match the identified needs fairly well. There are certainly some gaps in terms of legal needs that we'd like to see grow over time, but a lot of that traces back to available education. And one of the things that we were hopeful of when we moved through the pilot was a lot of the universities and colleges talking about micro-credentialing and the idea that you could have more focused education and training in particular areas. Okay, and so just as we wind down the last few slides here, limited licensees are bound by a code of professional conduct. They don't accept retainers, so this is one of the big differences between lawyers and limited licensees. The area of solicitor-client privilege is a bit of an open question mark, remains to be decided. I can talk more about that if folks are interested, and limited licensees are independent. They're giving independent legal advice within their permitted services, and they can give and accept undertakings, again, within their permitted services. They're insured. The Canadian Lawyers Insurance Association came on board. They might need to rethink the title of their organization over time, but limited licensees in Saskatchewan are insured by CLIA, and this is administered in Saskatchewan through the Saskatchewan Lawyers Insurance Association. Regulation will be ongoing, and so just like we do for lawyers, there will be licensing renewal, the levy, continuing professional development. For limited licensees, it's at 6 hours a year. 2 of those hours are ethics as compared to lawyers, 12 hours a year. 2 of those hours are ethics, and they have access to all of the Law Society programs and resources, including continuing professional development that lawyers do, and will slowly have them infiltrate all of our processes and systems over time. We're in the first year of implementation, and so that will take us a bit of time to fully get up to speed on. And so lastly, where are we? As of May 1st, we have had 46 applicants, so this is a month back data. We have slightly higher numbers here as of June 1st, but 46, or almost June 1st, 46 applicants, over 30 approved, 6 pending, 1 withdrawn, and 4 denied. 2 of those will likely go to appeals to be determined. And where are we seeing them practice from highest to lowest? So the numbers aren't attached to this, but essentially a lot of these folks are doing work in administrative tribunals, provincial courts, so small claims, summary offenses, traffic, those types of areas, wills, power of attorney, healthcare directives, assisting self-represented litigants. This is a nice one that we were pleased to see. And the last thing I'll say before I wind down is we have also had a retired lawyer come back and license in the limited licensing category. It's a lower practice fee. It's a discrete area of practice. Why not? And this would be one of the self-represented litigant areas that we've seen. A little lesser in the family law, some corporate legal services, administration of estates. That's the under 25,000, so small estates, and then some work in land titles, contracts, and other areas like that. So far, this seems positive to us. We'll begin to go through the tricky parts of regulation, including complaints and other regulatory processes, but a good start to a flexible regulatory structure that allows for limited licensees to engage in these areas of practice in Saskatchewan. Thank you.
Wonderful. Thanks to our presenters. So we're happy to open the floor to any questions or comments that anyone might have. We've got a bit of time for questions and discussion. Perhaps while people are thinking of questions, I might just lob a couple to Max and Pamela. would it be right to understand that then all of the providers who are limited licensees, they're all charging for their services? Is that correct? And or have there been any applications from people who might work in community organisations and are looking for authorisation of this type?
The first round of folks coming through are charging for their services, yes. We do anticipate seeing the others that you mentioned, more community-based organizations or other types of clinic models, to be determined in some respects. And also, we have made the same provision for pro bono services that we have for lawyers for limited licensees. So as our limited licensees retire, they can come back and deliver pro bono services, and they'll be insured for that work. So to be determined.
Thank you, Marcus Manuel from ODI Global, a think tank in the UK. Fascinating. Thank you so much. I'm interested about the relationship with legal needs surveys that you based it on. On the basis of the needs you see in the province, do you have any idea of the number of limited licensees you want to see coming? Are they going to be the same number as lawyers? Are they going to be 3 times as many? I just wondered if you've had any thoughts about that in the process. Thank you.
We did a bit of thinking ahead work, and thanks to Stats Canada for giving us a sense of the paraprofessionals, or folks who would call themselves paraprofessionals in the province. So that number based on 2016 data, not the most recent. They changed the survey a little bit, so it's difficult to compare. You've got about 1,300 folks who would potentially come in. We wouldn't expect those numbers. It just wouldn't track that way. That number of individuals generally wouldn't be interested in doing this type of independent work. Our thinking initially over the first few years is probably about 100 will be what we see. Does that meet the need? No. There is no version of limited licensees and lawyers sort of privately structured without public funding that would meet the available needs at the price points people require. So this is meant to create those opportunities for engagement by both folks in private practice and also a licensee pathway for the more public services. And over time, we would love to see that, and we're very open to those types of conversations. The other thing that we will work on is making sure that there are no barriers to lawyers and limited licensees working together. So fee sharing was recently addressed in our rules, and some of the next thinking we'll do is around alternative business structures and entity regulation. So the forms of practice as they currently exist across Canada, Saskatchewan's not unique, have some restrictions around how folks can engage in the delivery of legal services through the models of the businesses they can have. So that will be something we tackle over time, and we would hope to see fewer barriers there as well. This has also been one of the things we communicate to lawyers, and a lot of lawyers see the opportunities here, particularly in rural and more remote areas. Some of the first applicants we had who weren't in the pilot were from smaller towns, the Yorktons and others, that they see the possibility here to retain good talent, paraprofessionals who are delivering excellent services and can be part of the profit-making enterprise of the delivery of law, because the need outweighs the supply.
I'll just add a couple of comments to Pam's very eloquent response. I think the next phase of this program, it seems to me, is an opportunity to really rethink or to start to think about limited licensing and be very creative in it. And I mean, personally, in the position I fill, I haven't really thought until now, what is it that, as a government, we could do with limited licensees in government? Instead of having nothing but Crown Counsel in the Ministry of Justice, do we start to think about the possibilities in public service, in legal service delivery of limited licensees? And I mean, that will take some time to think through, and I'm sure that there will be many other areas of practice where there will be some creative thinking and some consumer thinking about, what is it that the market out there, what is it that the clients want from limited licensees? So, I think that the sky is the limit. On the other hand, there will be, there's also an information asymmetry, as it were, where I don't know how many people out there know about the limited licensee program, and so it may take some time to get that word out there. But I think there's a real opportunity there for all of us in a legal system.
Hi, Jane Mallon, CEO of Legal Aid Saskatchewan. I just want to say it's a pleasure to work with these two incredible professionals up here. But one of the things Legal Aid is really interested in is how, on the access to justice front, is how we can expand our services in rural and remote areas, and in particular in communities in the far north where many of our clients live. Almost 70% of our clients are Indigenous. And how do we get our services to clients in those communities? And one of the things we're thinking about are community legal workers, justice workers, and how do we expand our services where we can't get lawyers into those communities in any permanent way. And it also supports our commitment to reconciliation and economic development in those communities as well, if we can hire people embedded in community that are licensed to practice in some limited way that can supplement the services that our lawyers are providing and bridge that gap, as we see a real difficulty in finding lawyers in rural and remote communities. So, thank you.
Absolutely, and in the final report, we do a bit of an overview of the educational institutions we talked to, and some of the really promising conversations that were with the Saskatchewan Institute of Technology and the First Nations University of Canada, which is based in our province. So some real opportunities. Right now, I think what we see is fragmented courses as opposed to maybe some of those more coherent pathways. But what we were also told was the more you see a volume increase, the more the educational case is made, essentially. So cart horse in some respects, as Ashley, I think, would highlight. So we're hopeful, and some of those conversations will continue over time. And also, we heard from colleges of law that, again, some of that micro-credentialing or ability to take just courses historically hasn't been as much on the radar. But the law schools, I think, are starting to offer this type of programming more and more. I'm thinking of a few programs in Ontario, and certainly our own college has at least one course that I'm aware of, but that may, again, grow over time. And some of this may require public investment if we are trying to target the groups in the areas where you're not likely to see a profit motive to do that work.
And just to add, the education lens, there's literature that states, and we see this in law school curriculum, where law schools are situated in urban centers, the folks that go and take law school in the urban centers, they end up practicing in those areas. And so part of what I'm looking at in my research is the flexibility, the accessibility, and some of that is online learning, right? And so when you talk about micro-credentials, which are typically online, or additional courses, having that education conversation with stakeholders and making education accessible from anywhere can be really helpful in accessing, rural communities that are otherwise inaccessible by other formal education training institutes.
Rob Lapper. At one time, I had a career in a law society. that regulates paralegals. And I want to commend Saskatchewan for a couple of things here. One of them is there's some actual cooperation between the Law Society and the government, which from the jurisdiction I am now from, British Columbia, is noticeably absent in our current regulatory initiatives. My question is, we're now starting to see, thinking about limited licensing, credentialing on a limited licensing basis, again, a big fan of that. But, we spent quite a bit of time about 10 years ago at the Federation of Law Societies level doing a national mobility project so we could recognize each other's credentials as we went across the country and eliminated barriers to licensing. As we start to see a patchwork of new regulatory or regulated professions or limited licensees emerging, which look a little bit different in each of the 2 or 3 that are now seriously doing it, is there going to be an initiative to try to, standardize or recognize credentials and create a mobility? Because, of course, that is one of the, in our kind of recent economic understanding of what Canada is, we want to actually deregulate barriers to mobility.
It's very much an active conversation amongst law societies. As you rightly note, we have sandboxes and initiatives happening across the country, and folks from the Federation are here, and other law societies are here. So very much an active conversation, one we will take forward. Again, the States has also been doing quite a bit of work around this harmonization idea, and they've got 50, we've got 13, so maybe we'll beat them, we'll see. And there's the mobility is one part of this, but there's also, professional reciprocity in terms of responsibility and ethical obligations and other bits and pieces like this. So we are active to the conversation, and will hopefully be back at conferences to report on positive developments. But the one thing that I would say is, we have Ontario paralegals licensed in Saskatchewan. So this was one of the first groups that put up their hand and said, what can I do in your jurisdiction? We wouldn't have that back yet, just due to the nature of the licensing and the way this works. But over time, I think we'll have those conversations and try to arrive at good places.
That's great to hear. And I just have one observation for Ashley. The Research Institute with which I am now affiliated is doing a major study, a cross-jurisdictional study of education and education of legal service providers in Canada, UK, and Australia, and a comparative study, and that's relationship to access to justice. And I'm just wondering if there is a piece of your doctoral research or work that could link to that. So I'd be happy to engage with you at some point.
Yeah, let's chat after. Yeah.
We have a little bit more time for questions. Happy to get them. Perhaps while anyone's formulating one, can I ask another question about the reporting on the limited licensing? I'm curious, as you're sort of tracking the impact, Pamela, to the extent that the limited licensees might be involved with your sort of adversarial processes rather than transactional wills, that sort of thing. Have you tracked, or will you track sort of maybe what side of disputes limited licensees might be on? And for example, say landlord-tenant, I think we like to hope that limited licensees, perhaps like was the dream for Ontario paralegals, that they would help tenants, but it's not clear that they are. It seems like they're more helping landlords and helping sort of improve access to justice, if we can call it that, for landlords. So I wonder if those sort of factors are being tracked or could be tracked, or whether that would be interesting.
No, it's an excellent question, and our reporting didn't necessarily get into that level of detail. Anecdotally, we know that for the tribunal work in particular, these were folks on both sides in some respect, particularly around landlord-tenant, skewed a little bit more to tenant than landlord. Also because just the nature of some of that work in Saskatchewan already has agent activities and other built-in aspects. So a little bit different model than in Ontario. So we probably won't track at that level of detail. And one of the things we're mindful of is not placing additional burdens on limited licensees in terms of reporting and data tracking that we don't also place on lawyers. So, I mean, I would love to do very detailed data collection on both lawyers and limited licensees, but we have to be fair as well in some respects. So in our jurisdiction, you can place your services, the areas of law you provide services in, through our Fine Legal Assistance Directory. It's not a Fine Lawyer Directory, it's a Fine Legal Assistance Directory, and through that, we'll be able to track some of this and understand those areas. Also through our licensing with limited licensees in particular, but that nuance of some of the, which side, or do you only do one side and not the other, we probably won't get that granular simply because we don't get that granular with lawyers. If we were to get that granular, we'd roll it out across the board.
That sounds awesome. Let's roll it out across the book. Okay, any...
What I didn't see in your model in Saskatchewan was the participation of limited licensees in governance. Can you speak to that?
June 18th is the AGM of the Law Society of Saskatchewan, where you will see a resolution to bring a limited licensee onto the board of the Law Society, which needs a 2/3 majority vote at the AGM. So ask me in a month. And this is something that we'll look at over time, and we're also doing some broader work around governance. I mean, many law societies across the country are doing some governance work right now. We tend to have big boards. It's not necessarily fit for purpose. And so it's also part of a broader conversation that we're having around, the right size board structure. How do we be representative if it's not just on the basis of geography and other factors like that? But certainly the licensing categories are one part of that, and with a view to, you would see limited licensees grow over time in terms of numbers would be our projection at the moment. Yeah.
I thought I saw someone approaching the mic, but maybe not. No, okay. Another question, perhaps thinking about the broader approach here. You mentioned that, I think, Pamela, that maybe some of the ethical considerations are different in not-for-profit versus sort of fee-charging contexts. And do you think that there's any argument, or is it, to what extent could it be considered that, maybe not all sort of supported entrance to, or sort of supported providers may not all need to be regulated. That, like, for instance, we might be okay if we actually don't regulate not-for-profit, and perhaps that reaches back to the idea that in a few provinces, if you're not providing help for gain, fee, or reward, then you're in an exemption category already, so you're sort of not covered. Is that something that you think is possible to consider within Saskatchewan's sort of broader approach, or worth considering?
No. Thanks for the question. I was going to swing back to the slide, but it'll take too long to find it. So within that exemption category, which is within our rules, we have the ability to exempt from unauthorized practice. I mean, you'll already find university law students providing services through an approved pro bono organization, and certainly, that's within contemplation. We don't love the idea of making it on the basis of whether you charge for services or not. Regardless of whether you are being charged for services, you are owed ethical, competent conduct. And I know historically that has been the regulatory tool or the legislative tool in terms of where the barrier lies. We have a flexible regulatory structure that would allow us to do that slightly differently, so the basis isn't on fee, but rather risk, oversight, and in one of the footnotes of the report, and Max, you were part of the workshop where the government and the Law Society got together and said, you know, what's a policy framework for whether you would float through an exemption or whether you would need a limited license to deliver services. And so we go through a set of criteria to try to assess the risk to the public. And I mean, the fee, if someone's being charged a fee, is one part of that overall conversation and discussion.
Ashley, I don't know if, I mean, I know your work is operating in an unregulated area. Do you have any, and not really about whether that should be a regulated area, but do you have any thoughts on, you know, the scope of regulation or whether everyone needs to be in a regulatory umbrella?
That was a big question.
Sure.
I mean, I think if we look at the education landscape, I have some concerns, and also, you know, looking at the way Saskatchewan, I think it's fantastic, but also concerns about how you navigate the education of each individual person. I mean, it's a case-by-case situation, and so I think about scale too as well, which I'm sure you've already considered. But also too much regulation.
We're
can be a problem.
Saskatchewan, which is why it works, to be
Yeah.
clear. Yeah.
Yeah. Yeah, but also too much regulation can create barriers too. I mean, Trabuco's work did that, essentially outlined that in her dissertation. But no, I don't take a stance on regulation at this point.
Okay, wonderful. Well, we're out of time, so I hope you'll join with me. Thanks for your engagement and questions. Hope you'll join with me in thanking